Hello, my name is Paul Knudsen. I'm the managing attorney for the Family Law Division at Denmon Pearlman. We're a St. Petersburg, Florida-based family law firm. We operate all throughout the Tampa Bay area. I want to take this opportunity to go through and help some of you that may not be able to afford an attorney right now and help you with the situation of filing for your dissolution of marriage. A dissolution of marriage is just the technical and legal term for divorce in Florida. If you go ahead and head to Google, you can type in Florida Supreme Court Family Law Forms. This will bring up Family Law Forms, Florida Courts, and that is the overall form bank for family law from the Florida Supreme Court forms that they have for everyone. Now you're going to go down to the drop-down menu right here, and there's going to be dissolution of marriage and in parentheses divorce. You're going to click that. You're going to go in and you're going to decide what kind of divorce petition do I need to file. And there's 4 options for you here. A simplified dissolution of marriage is a situation where you don't have any children, you don't really have any property to divide, any small things that you might have already had to divide, you've already done. You're going to go into that form. You're going to review it. It's very easy, very straightforward, and the 2 of you are going to sign it, and you should be able to get in and get a hearing very quickly and get your divorce wrapped up. Now, I'm going to go through and do a petition for dissolution of marriage with dependent or minor children because that's the most involved one. So when you're ready to move forward and start filling this out, you go ahead and click the PDF option. Now it's going to take you into the Florida Supreme Court form for petition for dissolution of marriage with dependent or minor children. It's going to have a whole bunch of instructions for you here. These are very important, and read them because they're going to give you a bunch of very good information, and it's going to have a lot of definitions that you're going to come across as you move forward. Now, as you get down, I believe this is page 3 at this point, it's going to have a list here for you that I'll highlight. And these are the documents that you're going to have to file as you file your petition. You're going to, up front, have to file this Uniform Child Custody Jurisdiction and Enforcement Act affidavit. We call that the UCCJEA. Up front, you'll also have to file a Notice of Social Security number. You'll also, along the way, have to file a Family Law Financial Affidavit, Child Support Guidelines Worksheet, Certificate of Compliance with Mandatory Disclosure, and a parenting plan. Now it goes down and it discusses more of the issues that you need to be aware of when we're talking about parenting plans and parental responsibility and time sharing. Again, there's a lot of very important information in here as you go about filling this information out on your own. I'm going to scroll through because obviously when you pull up this document, you're going to be able to read through this in detail. Now, going about filling this out, the first tricky question for everyone is they don't know, and really it's not surprising that you don't know what judicial circuit you're in. Now, because again, we're St. Pete based, I'm going to go ahead and say we're in the 6th Circuit because we are, and we're in Pinellas County. Now, if you don't know, all you have to do is hop onto Google, type in Orlando, Florida Judicial Circuit, Miami, Florida Judicial Circuit, and it should very quickly pop up on Google what circuit you're in. Now, as far as the case number in the division, you don't have to fill that out yet because you do not have a case number and you do not have a division as you haven't filed the case yet. So you're then going to go in and you're just going to start popping in the information. You're the petitioner if you're filling out this document, and you're the one that's going to be filing it. So let's say you're a woman named Jane Doe and your husband is John Doe. You're going to go ahead and plug that in. Then you're going to plug in your name here, full legal name. You're going to highlight that usually both of you have been a resident in the state of Florida for at least 6 months, but if only one of you has, that's fine. You have jurisdiction over the divorce itself. Then you're going to highlight whether or not only one of you is a military member, neither of you. All you have to do is click that, and you'll have the checks. Now you're going to go through and you're going to put in what we call our marriage statistics. The month, day, and year you were married, the date you were separated. And an approximate is totally fine. We do it all the time because sometimes people have no idea the date they were actually separated. They know they got ticked off. They left the house sometime June of 2018. We use that. We just indicate that it's an approximate. Then you're going to indicate the place of marriage. Now in section 4, you're going to go through and you're going to list whether or not you're pregnant. And then you're also going to list any minor children you currently have. The minor children conceived of the marriage who are not common to both parties is also important, because if a child was born to an intact marriage, it's assumed that the child is a child of the marriage. It just seems obvious, right? But there are the occasions where they are, quote unquote, illegitimate children. And so there's going to need to be a disestablishment of paternity that needs to be done. Now, you're also going to click here that you either are filing your financial affidavit up front or you will be filing it. And it doesn't have to be filed up front. Mandatory disclosure law, which is Florida Rules of Family Law Procedure 12.285, you have 45 days from the date the petition is served for both parties to file their certificate of compliance, their financial affidavit, and serve on the other party their mandatory disclosure list. Now, the Uniform Child Jurisdiction and Enforcement Act must be completed up front. And the reason that must be completed up front is that otherwise the court doesn't know that it has jurisdiction over the minor children. So you need to do that at the same time and file it at the same time you file your petition for dissolution of marriage. You also need to file your Social Security affidavit at the same time. Next, you're going to go through and pick your grounds for dissolution of marriage. I can tell you that I've only ever alleged the marriage is irretrievably broken. Florida is a no-fault state, so as long as one party's sitting there saying, I don't think we're going to be able to reconcile, the court's going to grant it. So most cases, you're just going to click that option. Marital assets. There are plenty of cases where there are no marital assets or liabilities. Shorter-term marriages, people just don't have any money. Just go ahead and click that option. Now, if there are marital assets, you're going to either select that you want them to be, that they're going to be listed in the financial affidavit, which of course they need to be, and that you want them divided up pursuant to a written agreement between yourself and your spouse. Or if that's not an option and you don't think that's automatically going to happen, then you should always check this next box. The court should determine how the assets and liabilities of this marriage are to be distributed. Additionally, it gives you the option of making what's called an unequal distribution claim, saying that, hey, I'm the petitioner. My husband wasted a whole bunch of our funds on gambling, on booze, on other women. I should be entitled to a portion of his property because, and then you're going to go ahead and explain in there why you think that you legally have a chance. Next, you go to spousal support and alimony. It's the same concept. Everyone just knows spousal support as alimony. So if you're requesting alimony, you're going to go ahead and click that button. And then you're going to go into how much you're asking for. Now, this is a tough concept because you're not going to know how to claim that. And that's a lot of the reason why people hire attorneys. So realistically, what you should do is you should go through upfront put together your financial affidavit upfront, review it, figure out what your needs on a monthly basis are. What your deficit showing is, and go ahead and make your best case claim on your petition. Because if you don't ask for it upfront, you're not going to be granted it at the end of the day. Now, next you're going to get into the parenting plan. What do you want to do with your children? The minor children or child currently resides primarily with petitioner, respondent, or other. You're going to say where your children are laying their heads at night. Next, you're going to get into parental responsibility. And again, there's a long discussion up top as to what parental responsibility is. It's typically going to be shared by both parents, but there are the situations where one of the parents having responsibility for the children is going to be detrimental to the child. So you go ahead and you put that in here. that you're asking for it. And again, you have to do it up front or you're not going to be awarded it. So you put it in here and you state why it'll be detrimental to the child. Well, he's an alcoholic, she's a drug abuser, they're in jail for domestic abuse. There's a lot of scenarios where it may be appropriate, but you need to put it in the petition. Next, you're going to get into why you want the parenting plan that you want. And you're just going to go through this whole provision. And again, it's really, really laid out there easily for you in that, like above, we have, choose all that apply in section 1, paragraph 2, right? So you can select all of these options. But down below, when you get into the parenting plan, it says choose only one, right? So you can't, realistically, as long as you're paying close attention and you're following the instructions, your life's going to be easy and you're going to be able to do this properly. Next is child support. And again, this is a choose all that apply provision. So if you just want child support, the court's going to order child support. It has to. But go ahead and select that you're requesting child support to be ordered. Select whether you're filing the guidelines up front or it will be filed at a later time. Next, the date of separation and the date of filing this petition is important because you can go back up to 2 years to ask for retroactive child support. So the court's going to look at this and they're going to say, okay, did the person ask for a retroactive award of child support? And so it's really important, again, up front to ask for what you may be asking for in the future. Now, there are certain circumstances where child support may be legally supported past the age of 18. Now, it's pretty seldom, but there are children who have mental or physical incapacity, which began before 18, which is going to give the court the ability to grant child support beyond the normal age of 18. And you're going to go ahead and put in why you think it's appropriate and what the mental or physical incapacity is. Next, we've got whether or not you're asking for medical or dental insurance. Of course, you should ask for that. How you want the medical or dental expenses to be paid. Usually, this is what the court is going to order according to the percentages of the child support guideline, or what we call pro rata split, meaning, there might be 60-40. One party makes 60% of the net income, the other party makes 40% of the net income. So we divide it up consistent with your net incomes. Finally, we have other. This is where if either of the parties wants to go ahead and claim that they want to be restored to their former legal name. Other relief, of course, if you're doing this with an attorney, which I can't imagine an attorney using just the boilerplate form, but I suppose they're out there, you can ask for attorney's fees in this provision. And then you're going to come down here and you're going to have your request section. And you're going to go ahead and you're going to select everything you want and everything you ask for above, and you're going to click on these buttons. And realistically, if you're asking for alimony and you have some property and you have children, of course, because you're filling out this form, you probably should be selecting every option in section 6. And then you're going to go ahead and print this out, and you're going to date it. You're going to sign it in the presence of a notary, and then you're going to go ahead and send it and take it with the other forms that you need to file up front, which again are up here under the special notes section. And you're going to take it down to the clerk of court and pay your initiation fee, and they're going to file the case for you. If you have any questions, don't hesitate to reach out to our law firm. Again, we're Denmon Pearlman, and we're in St. Petersburg, Florida, and we represent all the Tampa Bay area. So feel free to just plug us up in the Google search and pull up our number. We accept, obviously, online submission forms also. So feel free to reach out if you have any questions. Thank you.